This is the current federal tax developments for the week of September the 23rd, 2019. Current federal tax developments are brought to you by Kaplan Professional Education and by your state Society of CPAs. This week we're going to look at a few developments. First, we want to take a look at something we discussed last week briefly, the IRS's release of final regulations under 168K for the bonus depreciation rules under the Tax Cuts and Jobs Act and some additional proposed regulations in that area. We're going to talk about the government shutdown causing the IRS to lose the ability to have a statute of limitations extended. We'll talk about the IRS making an offer to 200 taxpayers who are part of a microcaptive insurance program. The IRS has had some successes in court against those. They're now offering 200 taxpayers the right to settle, most likely on terms most favorable to the IRS, their claims or go to court and risk being another loss is the way the IRS is phrasing this. We'll talk a little bit about what the program is and the pros and cons and some of the potential issues you may be facing there. We're going to talk about a power of attorney that just wouldn't die for a son that caused him to be deemed to be responsible, or at least in a position of authority, I should say, to deal with his father's affairs that rendered the father no longer financially disabled for purposes of extending the statute. That's true even though the son was not exercising the power at the time. And finally, we'll talk about a CPA that was ordered to turn over tax returns of his client. We'll talk about how the court decided that the returns should be required to be given from the CPA to the plaintiff in the lawsuit and the issues we deal with when we have cases like that with our clients. Well, we got something coming up I've mentioned the last couple of weeks. I want to remind you, we're starting to do these sessions with Cal CPA and some of the state societies where we are recording webinars live. We're doing live sessions. They're being recorded. We're doing the rebroadcast. The first one of those will come up October the 16th, Advanced Partnership Issues, featuring the new partnership audit rules. That course will start at 6 a.m. Pacific Daylight Time, the day after the 15th deadline. And we will also start at 8 a.m. There are two sessions. They start 2 hours apart. Depends upon which time zone you're in, probably which one of those two is more appealing to you, because obviously that's 9 a.m. Eastern Time for the early start. And that would be, as I say, 11 a.m. Eastern Time. You're going to take the later start. You really want to just sleep in that morning. You can wait till 11. Those of you in other parts of the country will adjust as appropriate for the time for those courses to start. We'll be talking about the partnership audit rules, how they work, and other advanced partnership issues. Now let's talk about our first item for this week. This is the proposed regulations under 168K. And this is Treasury Decision 9874. This is Regulation 106-808-19. It was issued on September the 13th, 2019. And these are regulations that deal with bonus depreciation rules under the Tax Cuts and Jobs Act. Specifically, they take a look at a number of issues. Now, one that people have been really upset about was the thing called the retail glitch. For those who don't recall, we had property that prior to the TCJA, we had three categories of property that would qualify as 15-year property. Following the TCJA, those three categories for a few months, basically for a little over 2 months, qualified, actually 3 months I should say, qualified to have full expensing when you put them in. Then we combined those three categories mainly into one single category, but Congress fouled up, forgot to give them the 15-year life, which also means they are not a short enough life to qualify for bonus, which means they're 39-year property. It's clearly a glitch. Congress did not intend to do this. The committee report is very clear that Congress didn't intend to do it, but they did it. And the IRS in the regulation said, look, we can't fix this. The plain language of the law makes these 39-year assets. And we don't have the authority to override plain language of the law. Congress is the only party that can do this. Congress has not done it yet. Now, the final regulations pretty much adopted the proposed regulations as is, but there were a few extra items thrown out at us in these regs. One key one is a special rule that allows a car dealer, mainly car dealer, boat dealers, those who have flooring accounts under the rules. As you may recall, under 163J, you're allowed to deduct that floor account interest and not subject that interest to the business interest limitation rules. 163J limits our ability to deduct business interest. However, the problem is, in exchange for that, basically those who have flooring accounts, like the car dealers, had agreed that they would not be able to claim bonus depreciation on any assets. This creates an issue because if you're a car dealer that mainly self-finance and has very little floor plan interest, and you're not paying a lot in that realm, so you don't need that special rule to protect yourself, you wouldn't be subject to the business interest limitations even if your floor interest was business interest. Then you're now allowed, under these rules, for a year where that's true, the assets you put in service for that year do not have to ignore the bonus depreciation rules. Remember, if your general rule, the code said, is if you're subject to this, you're in the floor, you have floor account interest, you have to ignore, you give up bonus. You don't have to here. So that's an interesting rule that's in place, and it's a part of the proposed regs, which you can rely upon at this point. We also had a special rule that talks about if you're leasing to a business that has a special treatment under 163J, the interest limitation rules. That'd be an electing real property business, an electing farm business, any of these things, water plants, public utilities. We're looking at, again, the car dealers who do have this problem. The rules say as long as you're not a related party and you're leasing equipment to those entities, you can still qualify, assuming that you're the party deemed to own the property. You can still qualify for bonus. You're not going to be tainted because the company you're leasing to is in a tainted industry. That's not going to cause you to lose your bonus. That's also probably good news. On partnerships, they pretty much retain what they talked about in the proposed regs. The original proposed regs, so these now are final, they retained the bar on using bonus depreciation if you use the remedial allocation method for 704C. If you don't recall your code sections right off, 704C is what applies when a partner comes into a partnership. They bring in an asset. That asset has a different fair market value, probably because they've been depreciating it. The partners inside the partnership, are allowed to, the other partners, are allowed to be allocated depreciation that's equal to what they would have gotten had we actually paid full price for this property. And under the remedial allocation rules, where we just kind of create an entry to make this work, we treat that extra basis as a separate asset. The IRS had ruled in the preliminary proposed regulations that they were not going to allow you to use bonus on that because it would have the impact essentially of having all the depreciation go back. In essence, all that deferred gain on an asset wouldn't be very deferred. It would go back to the contributing partner. The flip side of that is all the others would get this big deduction up front. IRS decides we're not going to let that happen, so you're not going to be able to use the 704C remedial allocation. Property will not qualify for bonus. Also in the partnership realm, if you have a 734B adjustment, you've made the 754 election, you've had a situation like a partner leave the partnership, get bought out for something that's not exactly equal to his tax basis capital, which is normal. You're allowed to, or you have to write down if the 754 election is in place. That write up will not qualify for bonus if you do that under 734. The other thing a 754 election affects is when somebody buys an interest from another partner or they inherit the interest. Under the rules the IRS held in this case, these regulations under 168K, if you have a piece of property that is, if you have a partnership interest that's purchased from a partner and the partner buying it has never had depreciable interest in the property in the partnership, then they can qualify for bonus. But if the interest is inherited, even with the 74 election in place, right? So again, the first case required the 74 election to be in place, but then we could do the immediate write-off. If, however, the property is inherited, not purchased, the law specifically bars you from writing off inherited write-up in basis as bonus depreciation. So the regulations here also bar you from doing that with the 743B amounts in the partnership. Now, these regulations were ones, it's kind of interesting because back when we first started talking about regulations for Tax Cuts and Jobs Act, this seemed like the low-hanging fruit, the easy thing, the thing the service you're able to get out quickly. And there was a lot of talk that these regs would have been out by the end of last year. Well, now we're sitting nearly the end of September, and it's taken till now to get these rules. Effectively, yeah, we have a little problem here. The regulations are still kind of stacked up. That said, the service has been getting regulations back from OIRA faster, so we may very well see. We'll see how much guidance we get. The good news, bad news is, for me, is that I'm right in the middle of the year. All these extension returns, getting the final returns out, and the IRS keeps dumping these regulations on us. The good news for you is, though, there should be a lot to talk about in tax updates this year because all this stuff is happening, and now we need to get up to speed on this stuff doing our tax planning. And to be honest, there's a lot of areas in Tax Cuts and Jobs Act where we clearly still need guidance, and it'll be very helpful if the service can actually start getting out some at least proposed regulations to help us figure out how to handle these situations. Next up, we have an IRS news release, 2019-157. It was released on September the 16th, on Monday, and it's an IRS settlement offer regarding microcaptive insurance companies. Now, what we have here is the microcaptive rules in this case, microcaptive transactions, goes back to a case. The IRS's first big win was the Avrahami case, which was 149 TC number 17. We talked about it here on the podcast when it came out back in August of last year, August actually of 2 years ago, 2017. Since then, the IRS has had a number of other wins, and they have a whole bunch of taxpayers who are currently have exams going on this. In fact, tax analysts noted that we have 500 cases currently pending before the tax court on this issue, and then we have a whole bunch of other cases that are at earlier stages in the process. What the IRS announced this week is that 200 taxpayers who are being examined who are not at tax court yet are going to be given an offer to settle. We do not know much of anything about what this offer is and whether it be one you want to take or not. We have no idea what the terms will be. We've just been told 200 will get an offer, and they're not going to have a lot of time to make up their mind about taking it. The IRS does tell us that even though they're not giving us any real information on the proposed settlement, they do threaten us that appeals are not going to be a more favorable route for any taxpayer who's under this. That led to speculation, which was brought up in an article in Tax Notes Today that was brought up by a former IRS, in this case, let me get my reference here so I get the right issue, that was brought up by a former IRS official. In this case, I'm going to get my citation, hopefully, back to the gentleman in case, which right now, unfortunately, I can't find as I'm scanning through my notes. But the idea being that probably we're going to see a program here that's very close to what the IRS has been offering in appeals, right? What they'll do. And it is Stephen Miller, that's right, former IRS acting commissioner, who's with Alliant Group now. He suggests that probably the program, based on, he was at the service for a while at the top level, he thinks that probably the offer that's being made right now is similar to the offer that you're seeing in appeals. He said basically what he's been seeing appeals offer is full disallowance of deduction of premiums in a microcaptive structure. There will be a less severe line on the taxability of those premiums to the captive, and potentially even allow a return of funds from the captive to the user without nasty tax consequences. If you go to court, the IRS is going to push for nasty consequences at every step along the way. So the suggestion is that you want to settle right now rather than tie up the system. We'll see how many people take the IRS up of the 200, take them up and settle, and how many people decide to keep on fighting. Again, as I said, the big caveat right now is that we have no idea what exactly the offer is. We have Mr. Miller's speculation about the offer, and to me his speculation seems reasonable about the type of offer they'd be giving you. But we don't have much of anything else there, and obviously the IRS right now believes they're playing from a position of strength, having won cases. The catch becomes, will they keep winning? And if they don't win, would you get a better deal by waiting? That's probably up to you with the numbers we talk about in cases like that. It's probably up to you and your tax attorney to figure out what you're going to do about whether you want to jump in or not on this, because otherwise, you're probably going to have to litigate and hope you're the guy that wins, that your case is different. Next up, the government shutdown from last year comes up again. And this is a Chief Counsel email, ECC 2019-37017, issued on September the 13th of 2019. And this email deals with a case where the IRS had gotten a signed Form 872, consent to extend the time to assess tax, that was signed by the taxpayer. But there's a problem with their form. And that problem, even though the taxpayer had signed and agreed to extend the statute, before the document got back to the service, the government shutdown took place. So the IRS was unable to sign off on accepting the extension of statute. Now the question becomes, since the taxpayer basically consented to extend the statute and did so timely, is this a valid extension of the statute or not? The Chief Counsel email concludes very quickly that no, the statute requires both the taxpayer and the IRS to consent to the extension of the statute. The fact the IRS did not consent timely, regardless of the reason, and we understand they were not allowed to do anything during the shutdown, and they didn't in this area, so none of that work was going on, so it was not signed. This statute extension is gone. However, there was a question too, though, about a power of attorney, right? And this was a case where a taxpayer, in this case, had, given a range of dates rather than specific years on the power of attorney. Those of you who've done powers of attorney with the IRS knows that the IRS does not like that, and most often will reject the power of attorney. But in this case, it had not been rejected. Now, the Internal Revenue Manual warns against that because there is some concern, if it's not clear how the power was granted, that the taxpayer might be able to get out from under it, be able to say it wasn't authorized, etc. But in this case, they were asking, well, okay, regardless of whether it's good or not, we've accepted it, right? And who knows, it may have come in during this shutdown time. Who knows how all of this gets started. But they're saying, since it was accepted, is it valid? And the Chief Counsel concludes that even though the Internal Revenue Manual warns them not to take these because the IRS has some concerns about somebody being able to challenge validity, they said, as far as they're concerned, it still represents a valid power of attorney, and that the IRS should respect it at this point, rather than take the position that there is no power in place. Next up, we have our first court case today. This is the case of Stauffer versus the IRS. This was United States Court of Appeals for the First Circuit, case number 18-2105. The case was issued here on September the 16th, 2019. This is the case of a zombie power of attorney. What do I mean by that? Well, let's talk about the problem and the little issues the family had and how we ended up not quite solving those issues. In this case, the son, we start out with father and son are the two keys here. Father was elderly. He had some mental illness issues. He had signed a durable power of attorney and given that to his son. Now, if you read the court case, you're going to discover that son and father had a bit of falling out. Son got upset that father was allowing his girlfriend was spending money out of the account. Son was trying to put a stop to that using the power of attorney. Dad didn't like that. They eventually had a falling out. The son had stated he wouldn't carry out the duties. The father and son weren't even talking. The dad wouldn't answer the phone calls at that point. The son said he had told other people, his sister and other individuals, the attorney, that he was no longer going to act under the power of attorney. After the son got out of the picture, dad, of course, nobody's watching, so the son still has a power because the power had not been directly revoked, but he wasn't using it. And by the way, son's going to try to argue it was revoked. The court's going to hold under the facts of local law it wasn't because he didn't take the steps necessary. So dad, though, did not file returns for all of those years including the year that son had his falling out and going forward till dad died. When dad died, the sons appointed the personal representative. Son discovers all these unfiled returns, including a fairly substantial refund due to dad for that first year he didn't file. But the problem is the year dad didn't file was 2006. And dad died at the end of 2012, and they finally got the returns together and filed in April of 2013. Now, some basic math here. That 2006 return was due in 2007, and 3 years from 2007 is 2010. And as we know, your statute of limitations for claiming that refund would have died at the end of the third year unless there's an exception. Now, the son argued that IRC Section 6511 allowed him to have an extended statute under 6511H. Under 6511H, if a taxpayer is disabled, financially disabled, and by financially disabled it means essentially they're unable to act for themselves, and they didn't file a timely file the return due to that financial disability, that financially disabled person would be able to have the statute toll. So the son said, well, my dad was financially disabled from the original due date of that return in 2007 all the way until he died in 2012, and so the 3-year statute didn't start running until dad died. When dad died, that allowed me to step in as personal rep. The financial disability goes away. I'm able to file the refund claim way more than timely because I'm filing this in April of 2013. But the IRS said no. And the IRS pointed out that 6511 has an exception. You cannot, you're not financially disabled if there is another person, it says a spouse or another person has the right to act on the father's behalf, has the authority to do so. So was he authorized to act on behalf of his father? Now remember, the kid had told his father, suppose he had a falling out, he said he wasn't going to do anything under it. He supposedly told his family members he wasn't doing anything under it. However, there was never a formal letter that, revoked the power. And while dad drafted letters to revoke the power, dad never actually mailed those to son, so that no document ever went to either side formally revoking the power. The court looked at the rules under the applicable state law and determined that in fact son's power had been in place all that time. Now the question, does that existence of power of attorney mean that son was authorized to act on behalf of his father? The estate argued that to be read as authorized, really the court should require 3 things. First, that the person must have the authority to file tax returns on behalf of the disabled person. Now, the court points out that neither the IRS nor the taxpayer were disputing that the son, under the power of attorney, had the power to file the returns. That was actually one of the things granted to him. So they said, okay, that one, we're not going to talk about whether that's actually a requirement or not because it wouldn't matter. He would meet that even if that's a requirement. The estate also said he must have a duty to file the financially disabled person's tax returns, and he must have actual constructive knowledge of the fact the returns have not been filed. The appellate panel, basically the trial court and the appellate panel, rejected those 2 conditions. First thing they said no, the law says authority. It doesn't say duty. They said in many ways authority is kind of the opposite of duty. Yes, sometimes authority may come with a duty, but a duty requires you to act. An authority allows you to act. So the son had the authority. He was allowed to act, and that could be true even if he had no duty to act in that situation. So regardless of whether he had a duty to act or not, the court said that's not relevant, whether he had a requirement to do so. Secondly, they said there's nothing in the statute that suggests that this person who has authority to act has to have actual or constructive knowledge that the return had not been filed. so that he or she would then know to step in. The court said neither of those are found in the statute. So the court said, rather, we find that you were authorized to act. Because there was a party authorized to act on behalf of a financially disabled person, the fact that basically we don't worry about the fact that nobody did act. That existence of that authorized person, which is all the law says has to exist, is enough to make Dad not financially disabled at this point. And that means the statute died in 2010 prior to Dad's death, and that the claim for refund here was too late. That is significant because the estate was actually applying that to the next year. Presumably there's tax in the following year, 2011, and they were asking for money back as well. So as you might guess, this is an expensive loss for the estate. But it's a loss nevertheless that we kind of understand why that loss took place. Next up, a case that we run into from time to time. Our clients have a knack sometimes of getting themselves into financial disputes. And this is what happened in the case of Uniqlo International Inc. versus Yang Sup Cha et al. From the U.S. District Court of the District of New Jersey, case number 185759. This was actually released on September the 3rd. The case involved a suit by Uniqlo against Cha and some others, arguing misappropriation of funds. Uniqlo had actually hired Cha and related entities, individuals, to help them form a subsidiary in New York and begin operations. Now, according to Uniqlo claims, what they really did was they essentially absconded with the money. They claimed to have money that went in to lease space that, they're claiming never was actually existed. Nobody used it. It was paid to a related party who didn't own a building. And there's all these issues going on with about how this situation unwound. But the plaintiff in this case asked for copies of the defendant's tax returns from the defendant's CPA. So we have the defendant's CPA who's been asked to produce copies of tax returns. Now, that's an issue because obviously, generally, CPAs have a duty of confidentiality regarding their clients. We have section 7216 that generally makes it a problem for a CPA to basically deal with that sort of thing for a client. Excuse me there. To give client documents willingly to a third party. And we have state laws that make it confidentiality involving this. Under our state rules, we're not supposed to disclose client information. So the problem becomes now, can the CPA be forced to produce the returns? Well, his client objected to that right away and said, nope, shouldn't have to do so. Well, the court in this case, the district court, looked at the rules in the Third Circuit. And they said, well, this case would be appealed to the Third Circuit Court of Appeals. And if it was appealed, in essence, they would look for two tests. Generally, they said, because, we want to encourage people to be truthful on their tax returns, so we don't want to make it easy to have the returns subject to discovery because that could cause them to keep things off the return, hide things, and not pay the appropriate tax. So we're going to bias ourselves towards saying no, but that can be overcome if two things happen. There are two tests. The first test is the plaintiff has to show, and this is pretty much true of any discovery, the plaintiff has to show that the return would be relevant to the matter at hand. In this case, the panel agrees that it's relevant. How they reported the amounts received from Uniqlo, how they called them on the returns, how they were reported, how they were transferred, in essence, that would prove if they were handling this stuff, they claimed they hadn't absconded with the funds. And their tax returns would either be consistent with the view they hadn't absconded with the funds, or they would kind of be missing anything about the funds and this rent and all these other things that were supposed to have happened. they're saying that's clearly relevant data, right? Was there a rent paid? Was there a property leased? All these things. Did you actually report any of this on the tax returns, or do the tax returns show none of that happening? So they said relevancy has been shown, but the court said relevancy by itself is not enough because it's tax returns. Usually in discovery, if it's relevant, then they're probably going to get their hands on it. But because it's a tax return, the defendant has an option. If the defendant can come up with and say that there were financial documents, other financial documents besides the tax return, that would have the same information. That is, the tax return is not the only source of this information. Then, even though the tax returns themselves might be useful, in this case, the plaintiff would have to have relied upon the other documents. They couldn't get the tax returns if the same information would be available via other means. They'd have to go after the other means, not the tax return document. But in this case, the court found that, in fact, the defendant hadn't suggested any other place that the data the court had found would be relevant could be obtained by the defendant. In that case, the court found both tests were met. And because of that, the court ordered the CPA to turn over the tax returns they had prepared for the individuals and entities involved to the plaintiff in this case as part of discovery. This is a complex area of the law. And essentially, as a CPA, unless you're an attorney, this is not an area that you're going to be able to make the decision on yourself. It's going to take some legal guidance. Now, one thing to remember is it's not that difficult for a party to get a subpoena issued. Happens really quickly. But the question is going to be whether it's valid. Generally, if you're subpoenaed, you should consult counsel and get your counsel involved. Your counsel will likely get counsel involved from your client, and we'll come up with a method as to are they going to object to this subpoena? And if they are, then you kind of wait for the fights to die down, right? We're there, but we've had an objection filed. If they're not going to, maybe they and the plaintiff come to some agreement and decide what can or cannot be transferred over. That's also a possibility. But it is something to remember that this is not a clear-cut issue. Now, some states, like my home state of Arizona, has a specific accountant privilege statute, and that makes it even more interesting deciding when it can be gotten, at least in a state court situation. So again, one of those things where you really need to get your guidance from counsel regarding how this is handled. This is not a do-it-yourself project if you're subpoenaed for client documents. Be aware of that issue. Well, it is, again, hey, we're coming up on deadlines again. This time next week, you'll be getting your trust returns filed, right? And then we're heading for the individual returns, and then we're basically into CPE season. So be sure you don't get left behind with the IRS releasing all these regulations. Now's the time to sign up for CPE. We will be doing more of those rebroadcast courses from Cal CPA. I will also be doing live sessions. The rebroadcast courses will be offered by Cal CPA and many of your CPA societies. If you qualify for your CPA society's price, you generally are going to get a discount as a member, as opposed to paying the full price by going through Cal. If you're a Cal CPA member, you'll get a discount too. So take a look. We'll have them there. We will be having these 8-hour and 4-hour sessions on different topics. I'll try to let you know as those topics become available. And I want to kind of make sure we actually get them taped right so that, the live day doesn't end up with, oh, that didn't take. So as soon as I know that, I'll try to let you know the days we're coming up. We'll get those. We've got tons of courses coming afterwards. As I said, I'm coming up. I'm going to be visiting in the Detroit area, actually in Troy, Michigan. I will also be visiting in areas. I'll be in Minnesota, Minneapolis for their tax conference again this year. I'll do the tax conference in Seattle for the Washington Society. I will be doing some days in Boise, Idaho. I'll be in New Mexico again doing days this year. And of course here in Arizona I have days along with some days I'm doing for firms that have us come by and do updates for in-firm sessions. If you're interested in that, you can contact us. about those in-firm sessions. But by the way, the calendar is getting pretty full. So if you're interested in that, you'd have to move quick. And all of this is coming up now. We have this going on, and we get into January. We'll actually have some time coming up in Oregon also after the year begins. So we'll be various places. Check your state CP catalog. We've got our dates there. Other vendors have their dates for the state societies. You can get your live courses, get up to speed, because a lot's happening in taxes. This has been the Current Federal Tax Developments for the week of September the 23rd, 2019. As always, Current Federal Tax Developments are brought to you by Kaplan Financial Education and your State Society of CPAs. You can find information during the week about updates on our website at currentfederaltaxdevelopments.com. You can follow me on Twitter. That's at Ed Zollers. My email address, edzollers@currentfederaltaxdevelopments.com. I do follow discussions on the Connect sites for the Arizona, Minnesota, and New Jersey Society of CPAs. I also follow Cal CPA's Tax Talk. There, anybody who's a CPA or attorney in the country can go to Yahoo Groups, groups.yahoo.com. Have a Yahoo account signed in. You should be able to search for Tax Talk and ask to get in. Give them the fact you're a CPA, from what state you're licensed in, or an attorney where you're where you're a member of the bar. And you should be able to get in and contribute to our tax discussions there. I also follow along on the Reddit group /r/taxpros on reddit.com. And that, as I said, is a very carefully edited down discussion group. It really is a place where they've done a very good job of keeping out, the real problem we've had with these online before is they get overrun by people looking for free tax advice. The group is very good about sending people who are looking for free tax advice. They should go to the Reddit group called /r/taxes. That's where the general public goes. Tax Pros is for Tax Pros problems. You can find us there. The IRS may surprise us with more things. We'll see how things go in the coming weeks. We'll also get ready for the last couple of weeks here of tax season, tell you about things that come up then, and we'll get ready to hopefully be ready for CP seasons to start. Until then, good luck with your end of tax season, last minute clients, because we all know that group is a fun group to work with. And hopefully you survive your way through, so on the 16th, you'll be ready to get into CPE season. And in any event, we'll be back a couple more times before that due date comes in with our information here on current federal tax developments.